Hi, this is Patrick Conroy, and we're doing Chapter 4, the Court System, Settlement, and Alternative Dispute Resolution. If you've had me for some other classes, we probably introduced this subject, but parts of it can be easy to forget, so we're doing a good review here because it's important that you understand these things. The learning objectives. Identify and describe the sources of American law. Understand the need to prove the elements of a cause of action and remedies available. Describe the elements necessary to establish jurisdiction and venue for a particular court. Describe the courts in the federal and state court systems. Describe the advantages of settling a lawsuit before trial. And create documents for making a demand for a settlement. And prepare documents for settling and terminating a lawsuit. And describe the methods of alternative dispute resolution. So there's a lot to this chapter. This is going to take a couple of lectures. Learning objective 1, identify and describe the sources of American law. Courts are the ultimate venue for settling civil disputes. Federal courts get their authority from the U.S. Constitution. State courts get their authority from state constitutions. Federal and state courts share concurrent jurisdiction in some cases, meaning either could hear the dispute. Because of informal negotiations and alternative dispute resolutions, ADR, fewer cases go to trial. I wouldn't say few, but fewer. Each case must be treated, though, as if it will ultimately be going to trial. A thorough case analysis and preparation often lead to the settlement. Settlements are good because it can save the costs of the trial, from the client, and also to the other side, they might not be too sure how a jury will react to the situation. Okay, there are 4 primary sources of American law. The constitutions, and those include the federal U.S. Constitution, and every state has their constitution. Statutes, both at the federal level passed by Congress, and the state level passed by state legislatures, and even some municipal statutes. Administrative rules. Now, those are the rules that are made by government agencies. OSHA, FDA, those sorts of rules. Case law, precedent. Okay, constitutions. The U.S. Constitution established the conception, character, and organization of the government. Federal and state governments each have constitutions, and they both expand and limit the authority of the government and guarantee certain basic rights to citizens. I'm sure we've covered this before. This should all be familiar territory. Statutes are formal written laws enacted by a legislature and organized into codes. Federal, state, define and regulate conduct of citizens, business, government, and professions. Administrative regulations and adjudications, promulgated by agencies created by the legislature. So Congress creates an agency through legislature and gives them what they should be doing to enforce things. Their primary role is to enforce statutes, and they operate under the executive branch of the government. So the legislature sets them up with a law, and they might create rules to help enforce that law. And they operate under the executive or president branch of the government. Agencies are sometimes referred to as the 4th branch of government because they write rules, they enforce rules, and they adjudicate disputes. Now, case law, we have a long tradition of case law in English-speaking countries. They were created by written issued by the judicial branch, and these are decisions revolve the dispute before the court and serve as precedent or guidance for similar future disputes. So, based on stare decisis, which lends predictability and stability to the law. So we have a case, it's been decided, that's precedent. We'll stop there and pick this up with the next lecture.